When entering into a surrogacy arrangement, one of the first things that an intended parent will ask me is, can the surrogate keep the baby? So, in taking one step back, before this question can be answered, you do have to consider the law that's being applied to your process, because every state within the United States has different laws regarding surrogacy. So today I'm going to discuss Florida surrogacy laws, but it's important that you do consult with an attorney in the applicable state to understand the rights, obligations, and any legal risks involved, because the answer may differ depending on the state where the process occurs. So in Florida, we have various laws that govern surrogacy, which protect the parties' legal rights. So for example, within any surrogacy matter in Florida, the intended parents have to assume parental rights to the child, and the surrogate agrees to terminate any parental right to the child, essentially so she cannot keep the child. Within Florida, the only legal way that a surrogate would ever have to assume rights to the child would be if she gets pregnant with her own child, and that would be deemed a breach of the contract, as far as not following doctor's orders on when to be cautious of when she can get pregnant. And so if it's the surrogate's genetic child, that would obligate the surrogate to assume rights to the child and could potentially implicate other breach provisions of the agreement. The other scenario that is extremely remote but always possible is if the clinic were to put in the wrong embryo. Per Florida law, the parental rights could potentially default to that of the surrogate, but within many agreements, the parents would essentially indemnify the surrogate for any cost involved in having to essentially deal with that situation, because if a clinic ever put in the wrong embryo, it would obviously be an issue of determining who the actual parent is. But as long as it's the embryo of the intended parents that was transferred into the surrogate, the parents will always be the ones assuming rights to the child that's eventually born in Florida. For any surrogacy arrangement, it's critical that a contract be put in place setting out all the different parental rights of the parties. The parties should have separate representation, so the intended parents have an attorney, they pay for a separate attorney to represent the surrogate, and they perform a psychological evaluation. So once the parties have full medical and psychological approval, at that point they can proceed with the legal agreement to make sure that is in place before anybody gets pregnant, so that the parental rights of the parties are clear and properly explained to everybody before anybody gets pregnant, so that there is no issue down the road of any confusion on the parental rights. In Florida, there is a court process involved that's handled after the baby's born in order to finalize the parental rights of the parents. And that court order is what allows the birth certificate to be issued to the intended parents. So there is a legal proceeding involved. But statutorily, the parents' rights are protected in getting parental rights to the child born. If you have any questions regarding the surrogacy laws in Florida, please feel free to call me at 954-761-2929. Thank you very much.